Why is my bill so high in a divorce case? This question comes up all the time in our law practice, and we're here to talk to you about it. I'm John Henderson, and this is HH Law. Almost every day, people are asking a question, how did my bill get to be so high? Understanding billing in a law practice is something that each and every client really needs to understand. The lawyers need to be able to communicate to our clients as well. So I'm going to go over some of the issues that come up with billing. Generally speaking, in a family law matter, that is divorce, custody, anything like that, we are going to take a retainer on the front end. And that retainer is just money that we're going to hold in a trust account. And every time we spend a minute or 10 minutes or an hour working on your case, we're going to pay ourselves from that retainer. So let's say that right out of the gate, you paid a $6,000 retainer. We are going to take away from that, pay ourselves $300, $75, $1,000, depending on what the thing is that we did each and every time. And so that reduces your retainer amount. Most law firms, ours included, when you get down to around $1,000 or so, it's going to ask you, send you an email. You're not going to like it. And you're going to go, oh man, I can't believe this has already happened. But your retainer is running low. We need you to replenish your retainer. A lot of times, other law firms in Charleston and all around do a similar thing. They're going to ask you for $2,000 or $3,000 just to keep that retainer replenished, so they're holding plenty of money to continue fighting for you. Now, the problems come in when people don't quite realize how their bill got to be so high in the first place. And I want to talk about some of these reasons and why the bills really ramp up. The first thing that comes to mind is that we didn't know out of the gate exactly all the circumstances. So when we do an intake with somebody, we jump on the phone with them. They're saying, I really need some help. We tell them our retainer. They say, that's fine. We send over payment links, engagement letters, all the stuff to get them signed up. They're talking to the paralegal. And then we go to a temporary hearing, or maybe we get a call before a temporary hearing, and we learn that there's been some sort of child abuse allegation in that case. Or we learn that there's a bunch of money missing out of an account. Or we learn that social services has been involved and is investigating both parents in this circumstance. Now we've got a little bit of a wrinkle right out of the gate. Okay, so there could be, let's say, an emergency hearing that has to take place, or there might be just a really wild and crazy amount of preparation that has to go into that first initial temporary hearing that we didn't expect. Sometimes what that requires is talking to our clients nearly every day for 2 weeks leading up to it, reading emails, sending an investigator out to go check on various factors. Lots of work, really, from our support staff and from the lawyer to try to prepare for a temporary hearing. And now suddenly we got an $8,000 bill. They've given us $6,000. This has all happened in a matter of like 21 days or something like that. All because we have really some emergencies, some fires that we didn't realize and we're putting out. Now everybody is upset with that circumstance. So the remedy to this, and we try to implement here, is we want to find out what are the fires that are out there from the get-go so that we can offer a fair and reasonable quote to our clients. Like, we'll have a conversation often like this. The retainer is $6,000, but most cases are going to be between $10,000 and $50,000 to resolve themselves. That's a conversation we think is very important, and it's hard for us to gauge off of that first conversation, or maybe even a couple conversations, exactly where this is going to go, because our clients don't really know. They don't know what would be a fire that we have to attend to and what isn't. So it's really nobody's fault, but that bill really skyrockets if there are circumstances that we didn't anticipate and the client didn't properly prepare us for from the get-go. To provide a little context for the way a normal, regular case would go, which, by the way, no case is normal, no case is regular, but maybe your average case in family law is that first we're going to file it, or maybe the other side files it and answers. That all happens in the first month. Then second, there is a temporary hearing. There will be exchange of discovery, either informal or formally, which is we ask them for a bunch of documents and we ask them a bunch of questions. They ask us a bunch of questions. And then we enter into a negotiation. And if our negotiations with opposing counsel, with the opposing side are not successful, we go to a mediation. And then if there's an agreement at mediation, we go to a final hearing. And so in that context, in there, you're going to have that temporary hearing, a final hearing, and a lot of work that goes on in between. In a context like that, where there are no extras at all, everybody is reasonably getting along, you're going to be looking at probably around a $10,000 bill, maybe a $15,000 bill before it's all said and done. It could be much closer to 5 or 6 under certain circumstances if everybody's really crystal clear and the parties are getting along really well. But just as a reasonable expectation, if everything's going smoothly, you're looking at something like that $5,000 to $15,000 to make sure that everything is done the right way and we're buttoning up things the way they need to be done. But then there are a lot of other factors as well. One of those factors is whether or not a guardian ad litem needs to get involved in the case. You'll hear the term GAL used a lot. And in most cases where there's a custody dispute, we got 2 good parents, they can't get along at all. We're not sure. They're starting to weaponize the children. Dad's saying bad stuff about mom and vice versa. And they're trying to manipulate the children to like them best. This is human nature. Nobody's fault. This just happens. A guardian ad litem is going to be appointed by the court and step in. This is one of the things that drives up the cost of litigation, because now the lawyers have to deal with the guardian ad litem. The guardian ad litem is charging both parents to go visit the homes and to participate. But that guardian ad litem's role is really to report back to the court. Does mom's house look good? Does dad's house look good? Is there a strong preference here? Is one of them making some mistakes that could have long-term implications in the relationship with the children? Various different things that the guardian ad litem, is going to report back to the court. And so when a guardian ad litem is involved, that can drive up the cost of litigation pretty significantly. Another instance where the cost of litigation is driven up beyond that sort of normal classification that I originally talked about is when we have really high-end earners. And the reason why that matters is because you could have one or both spouses that own a business or multiple businesses. And so it's very hard for lawyers right out of the gate to understand the income coming from both sides. And so often you'll get a forensic accountant involved because things like this happen, is that the husband is suddenly claiming that he is making $200,000 a year. Wife is telling us, our client is telling us, whoa, we're living a lifestyle that is like 500 grand a year. I don't understand why he is claiming that we're not making that much money. This is our house. These are our accounts. These are our vacations. These are our cars. This is our second home. Why is he claiming a lower income? And so we can either petition the court or agree with the other side to get a forensic accountant involved in that circumstance. And when we're looking at those, what we typically do in a case, when do we know if we should get a forensic accountant involved? If we can't understand it, we're going to pull in an accountant to take a look at it. We have a business law division here at our law firm. And so if the lawyers can't understand the assets or where the money is coming from or where money has gone and disappeared, then we're going to ask our business side to participate a little bit and help us understand that. And if they can't help us understand where that money came from or where money disappeared to, then we're going to need to get a forensic accountant in and look at all the accounts for many years back, all the tax returns, help us understand a full scope of where that goes. But having complicated or high-end assets and net worth is one thing that also is going to drive up the cost of litigation. Another thing that is going to drive up the cost of litigation, and this sort of goes with the high-end divorce figures as well, is that a lot of times people, in order to get information, are going to have to file a motion to try to get that information. Somebody's not going to voluntarily turn over their company's business accounts without a judge ordering them to do it. And so you could have a motion to compel somebody to provide that information. You also, if they don't comply with that, would have what's called a rule to show cause. which is basically a hearing asking the judge to hold somebody in contempt for not providing information that they were supposed to provide or not taking some action. So a lot of times this cost of litigation really starts to drive up $20, $30, $40, $50, $60,000 and higher when we've got guardian ad litem, forensic accountants, rule to show cause, motion to compel, all of these different hearings going on, and everybody's threatening to go the full length, and there's maybe multiple mediations that fail, and everybody's threatening to go the full length of a trial, which is probably another $20,000 or $30,000 worth of work sort of at the end of this case. So those cases can get really, really expensive if people who have the means are not willing to compromise or to give a little as they also take a little. And as we're rounding this out, there's some other curveballs that can go on. And this isn't for high net worth people at all, but like if DSS is involved, that's going to drive up the cost of litigation. If there are some drug allegations going on against mom or dad or substance abuse problems, and we've got to look into that, that's going to slow it down and drive up the cost of litigation. All of these different things I'm going to call curveballs, and our responsibility is to provide high-level quality legal services. We can't do bare minimum stuff. That's not what we have pledged to do as lawyers. So we're trying to just represent our clients to the highest degree possible. But one of the things that I like to advise clients on the front end is this. How do I know if I should invest in a lawyer or how much money I should be spending with my lawyer? And really, it is an investment in your case. If you think that spending $15,000 or $20,000 or $25,000 on legal costs is going to get you an extra $150,000 worth of equity in the home at the end of this thing, then that is an investment well worth it. If, however, all you've got is debt, then you're going to want to tell your lawyer from the get-go, look, I need a lawyer to help us sort through all of this stuff, but we got to really try to keep cost minimal because really we have more debt than we do assets. Our incomes are pretty modest. Share that with your lawyer. That is a huge thing to try to help lawyers understand how to best help you. Nobody wants to be in a circumstance where they owe their lawyer a lot of money, and we as lawyers don't want to be in a place where our clients owe us money and maybe they feel like we're not representing them to the best. That is not true. We are doing our best no matter what, whether we're paid or not paid, until that agreement is resolved. So we don't want to be in a circumstance where there's some sort of headache about money between us and our client. All we want from our vantage point is we want to be paid for the work that we're doing, not a penny more, not a penny less. And the last thing, to keep the cost of divorce litigation low and manageable, you've got to understand that we are not counselors. We don't need a bunch of superfluous information to help us make decisions. Usually, we are asking you the things that we need. Now, obviously, we need a client who is going to give us information that we don't know exists out there, like the police were called to dad's house because of some event that took place. If we don't have any place to understand and know that, you've got to communicate that kind of thing to us. But generally speaking, we're not counselors, and we're charging a lot of money. Go talk to a friend, a counselor, somebody else about particular issues, particularly psychological or emotional issues going on with your case. Every time you talk to us, you just got to understand that we're charging you money. And what we're good at is providing you legal counsel, legal advice on what we can do and your options. We're not adept at handling any other emotional issues at all. So with that said, money issues become a problem from time to time. We'll have clients that'll send us over 100 emails in the first month of representation, or will call us 2 or 3 times a day, even though we've told them that that costs money. They still can't help themselves. We try to get in front of those issues, but this is a partnership between clients and lawyers. Everybody's got to be working together to make sure that those bills are manageable and that proper expectations are set. If you have any questions about billing, we're happy to talk to you and how we bill here at our office. If you're in South Carolina, this information is spot on for you. If you're not in South Carolina, we always recommend that you talk to a lawyer in your state. I'm John Henderson, and this is HH Law.